Good morning. Maureen Piercy on behalf of the appellant Mid-Continent Casualty Company, and I'd like to reserve 8 minutes for rebuttal. The first judgment that we're dealing with is a finding of a duty to defend under a commercial general liability policy that Mid-Continent issued to Geoffrey Holder Miller, Inc. And U.S. Home is claiming that it falls under the additional insured endorsement that affords coverage when there's an insured contract between Holder Miller's company and another entity, which there is a contract between U.S. Home and Holder Miller. However, the liability policy only kicks in when the U.S. Home is being sued for, pursuant to the endorsement, liability directly attributable to Holder Miller's performance of ongoing operations for U.S. Home. The complaint that was filed by Mr. Bell and his wife, Anita Bell, alleges 4 counts. 1 count of direct negligence by U.S. Home and Lennar, 1 count for direct negligence by Mr. Holder Miller's company, and then 2 counts for loss of consortium, completely separated out. There is no count for vicarious liability alleged.
Would you agree that count 1 contains allegations that do sound in vicarious liability?
There's 1 sentence in count 1 of the complaint that mentions U.S. Home's duties with respect to overseeing Holder Miller's actions, but it does not actually state a count for vicarious liability. If you read the entire count, and that would be paragraph 18, if you read the entire count, it says U.S. Home breached all legal duties. And again, this is a premises liability action. He talks about Glenn Bell as being a business invitee on the property. And this is an attempt to hold U.S. Home as the owner of the property liable. This court has held in Armiger that that is not, it's a non-delegable duty as the owner of the property for any dangerous condition on the property. That is not delegable, and that is not a vicarious liability claim.
The complaint, both the general allegations in count 1 plead the relationship between U.S. Home and Geoffrey Holder Miller, Inc. The responsibilities of Holder Miller on the framing components, supervision by the principal, U.S. Home. When I read it all together, the general allegations in count 1, it seems to me that there are allegations that support a claim for vicarious liability. So the question becomes, there are also allegations that sound like either joint liability or direct negligence. And then the case law talks about if including the Florida Supreme Court has said, they've said a couple different things, but one of the things they said more recently in 2005, and I'm looking at the Jones versus FIGA case, any doubt regarding the duty to defend must be resolved in favor of the insured, and the duty to defend arises when the complaint alleges facts that fairly and potentially bring the suit within policy coverage. And why are those allegations, when read all together, not sufficient to potentially bring the suit within policy coverage?
While there are some statements in the general allegations where they say U.S. Home and Holder Miller and their agents, that's why you have to come back to what causes of action are alleged, because otherwise you're putting an insurance company in a position of saying, well, they alleged negligence, but maybe 2 months from now or when we get closer to trial, they're going to allege something else.
But there's another problem, which is U.S. Homes doesn't control the allegations that are made against it. Correct. Which is why I think the case law says the duty to defend is read very broadly, recognizing that a plaintiff pleads whatever the plaintiff pleads, and if it is not cleanly pled, but there's enough there to potentially bring it within the scope of coverage, then the duty to defend kicks in.
I think under this court's precedent in the Transcontinental versus Jim Black, and also if you look at an older Florida Supreme Court case, which is National Union versus Lennox Liquors, they look to the causes of action, because if you're going to look more broadly at what is only in the general allegations and not in the specific causes of action pled against a party, then you're putting, basically, you're saying if there's anything in the general allegations, there's a duty to defend, and I don't think that comports
Well, the
with
general
Florida
allegations
law.
are incorporated into the cause of action.
Correct,
And they don't stand alone.
Correct, they are, but that's why you look at the entire.
So in order to review count 1, we have to look at paragraphs 1 through 21 of the complaint, not just paragraphs 16 through 21.
Correct, and I understand that, but I think if you also look at the fact that U.S. Home is a corporation, so it can only act through agents, employees. It's a fictional entity. So there have to be allegations that it was acting through agents or employees. Otherwise, there's nothing that it could do. And the way it's pled is U.S. Home, acting through its agents or employees, created these, it failed to supervise, it failed to comply with safety regulations, and it's specific allegations about U.S. Home's legal duties. When you look at the general allegations combined with the count 1. And then separately, there are allegations of Holder Miller also violating Holder Miller's legal duties, and that's why you have the 2 separate counts. And I think if you look back at the Goldschmidt case, and then there have been a couple federal cases since, or the King Cole case since then, and the General Asphalt v. Bob's Bear case, that's why they say vicarious liability has to be pled as a separate count to put somebody on notice.
But it's interesting because the Supreme Court in Goldschmidt also made very clear that the complaint, and this is a quote from the case, failed to set forth any ultimate facts that establish either actual or apparent agency or any other basis for vicarious liability. So there was an absolute lack of allegations that would support it. Here, there are allegations that would support a vicarious liability claim. There are also allegations that would support a direct negligence claim. But the Supreme Court has said it depends on the facts that are actually alleged.
I agree with that, Your Honor, but I believe that you still have to look at the whole complaint, and I don't think there's sufficient notice of a vicarious liability claim against U.S. Home.
Can I jump in on a slightly different track for a minute? The amended complaint and also the trial court's judgment talks about the fact that there was a crane involved in this. That the amended complaint alleged that the negligent operation of the crane by Holder Miller, could that potentially create vicarious liability on the part of U.S. Home?
The way it's alleged, I don't believe so. If it was alleged differently, while they say there was a crane and involved, the bells don't actually allege that there was some sort of inherently dangerous activity involving the crane.
But isn't that what the case says? Atlantic Coast Development, in Florida, the operation of a crane is an inherently dangerous activity.
Correct.
It creates vicarious liability for an owner/general contractor.
Yes, that case does say that. However, just because there was a crane involved doesn't mean that that was what he was alleging in here.
Well, they allege that there was the negligent operation of a crane by Holder Miller, right?
They allege specifically that there was a crane involved, and I believe the allegation was much more generic of the involvement of a crane.
Well, the record side is R3464. I don't know. I didn't look to the record, but that's what's in my brief here.
On the duty to defend, I think the issue is simply, do they have to allege vicarious liability as a separate count? Our position is they do. Obviously, the court doesn't seem to agree with me on that.
Well,
but
we're equal opportunity probers. The other side hasn't had their turn.
I wouldn't throw in the towel quite yet.
Okay. Well, looking at it from the perspective of, when someone files a complaint, they may put something in their general allegations, but they have specific causes of action alleged. You can't go to trial on something that you haven't alleged. You can't try a case on a cause of action that wasn't alleged unless the court allows it
Well,
the
there
complaint to be
is very
amended.
clearly a separate cause of action against U.S. Home.
Correct.
And so to the extent that there's a requirement of a separate cause of action, that's there. The question becomes, is it adequately alleged to put U.S. Home and the insurance company on notice that liability could be found against U.S. Home for vicariously? And it does seem like there are allegations that would support that.
Going back to the specific count against U.S. Home, I would put the points at paragraph 19 where it says U.S. Home breached its legal duties to plaintiff. They don't say U.S. Home is responsible because of some duty that Holder Miller breached. They're saying U.S. Home had these legal obligations, and that's when you come back to the Armiger case where this court said if you're being sued under a premises liability case and there's a non-delegable duty, that is not vicarious liability. Those are two separate things. They could have certainly put another count in there that said U.S. Home is liable because it is vicariously liable for Holder Miller's actions.
But that goes back to the question I asked earlier. How much does U.S. Home get, I'm going to use this word in quotes, punished by bad pleading on the part of a plaintiff?
I don't think they get punished for it. I think what the courts have consistently done in Florida is look at the complaint, read the plain language of it, what causes of action does it state, and do those trigger the policy? And I would submit that here...
And by the use of punish, I'm using it in the sense of
I understand.
they lose the benefit of insurance, not a real punishment. But it's troubling to me because of some of the language in the Supreme Court case and others, which do talk about how broad the duty to defend is, and they even talk about the potential for vicarious liability, which seems a little bit at odds with some of the other language about how specifically it has to be pled as a separate cause of action.
And as I see it, if the court looks at the fact that there's a due process issue, if a party's not put on notice of what they're being sued for, then there's a due process issue that comes up.
I'll tell you, I think a fair reading of the complaint is that U.S. Homes is being sued for its own negligence and also the negligence of its agents. So and this goes back to, well, is that sufficiently pleaded? Is it sufficiently pleaded as a claim for vicarious liability? Or is the allegation, the multiple allegations of joint and several defeat the duty to defend?
I think if you go back and look at the general allegations here, they have very broad allegations where they talk about Holder Miller and or U.S. Home. And then those get incorporated into the specific count. And I think that's instructive because that's a way how it becomes inartful in that sense, because they basically lumped everybody together there, but then they separate it out into the causes of action. So I believe under Armiger that they haven't sufficiently pled a vicarious liability count to trigger.
What about Grissom? Grissom has the broader language that I've alluded to earlier. If the allegation, they go even broader than what I said, if the allegation could bring the insured within the policy provisions, or if the complaint alleges facts partially within and partially outside of coverage, the insurer is obligated to defend. And don't we have that here?
I don't believe we do so here. Generally, the carrier comes in, they're given a complaint, it says whatever it says and whatever attachments there are to the complaint. And that's what they have to make a decision on. And I think that's why Florida has drawn a bright line on that. Look at it and look at the causes of action alleged.
See, this is what I think is the problem, is I don't think there is such a bright line. I mean, we kind of have the perfect storm here where you have these very broad, sort of fuzzy allegations combined with the Supreme Court language that says that if it could potentially bring in a vicarious liability claim, you know, it's, how do you limit that? What does that mean, potentially?
That's why I think
you a minute ago in your argument you said, well, they could have pled this. Well, are you saying that it potentially could have been a vicarious liability pleading?
I'm saying they could have, if they wanted to, put a count in for vicarious liability, but they didn't.
Well, I know they didn't label it as such. I think we're kind of getting caught up, and I know that's a convenient way to split these complaints apart, is what does it say? What does the heading say? But we have to look beyond that.
And again, I come back to the fact that they're saying U.S. Home had a legal obligation. And if we get into the inherently dangerous, the crane, the inherently dangerous instrumentality doctrine, that's non-delegable, that's not vicarious liability. So if you tie all of that in together, I think absent a specific count for vicarious liability, there's no notice that they're making a vicarious liability claim here against U.S. Home. It's direct negligence. And U.S. Home is a deep pocket, you know, so why not?
So is Mid-Continental. Right? I mean, if we're going to talk deep pockets, everybody's a deep pocket in this case, except for Bell, who's out of the case.
What, and
The answer
Holder
is
Miller.
yes.
Correct, and that's what I'm saying, you know, the Bells sued U.S. Home, Lennar, and Holder Miller. I think there was, you know, reading those allegations.
I mean, if we're going to go down this path, Mid-Continental was paid to provide coverage, including for vicarious liability. So if there's sloppy pleading by a plaintiff over whom U.S. Homes has no control over how they plead it, should they lose the coverage if there is a potential vicarious liability loss?
I think sloppy pleading doesn't make or break coverage. I think we still just have to come back to stick to what is the complaint alleging. I think that in the end will govern whether or not there's a duty to defend, and otherwise the carrier will always have to defend. If they have to read into it and say what might they allege, what counts might they assert, that leads us down the slippery slope of, if there's one sentence in here that possibly triggers something that they could later amend this, that creates a duty to defend. That's turning the
Of course, the problem was, I guess, they settled it before any further amended pleadings were filed, and
Correct.
you know, it got resolved pretty early.
Correct. The other issue is there are also employment exclusions in the policy, and there's a workers' compensation exclusion. I don't know if the court wants to continue on duty to defend, or
It's
time-wise, if I should move on to the duty
your
to
argument.
indemnify.
Until we ask questions, it's your argument.
Okay. If we could, I would like to move on to the duty to indemnify. In the event this court does find that there was a duty to defend, the duty to indemnify will be governed by the actual facts. In this case, there was a settlement between U.S. Home, Lennar, and the Bells. There were 2 releases and a dismissal. There was never a determination or an apportionment of damages. It was, I believe, $1.175 million in that they settled for. There was no apportionment between whether it was direct liability or vicarious liability. Their own attorney who represented them in the underlying suit specifically said this was going to trial. There was going to be a jury instruction on direct liability and vicarious liability. We were going to be hit with something, a sympathetic jury, but that's never been determined. Despite that, the court took some of the attorney's testimony and said, ignored other testimony and simply said, there's a duty to defend, there's a duty to indemnify, and you have to pay the whole thing up to your policy limit. And I believe that was error.
But the lawyer also gave an explanation as to why the vicarious liability exposure was significant, if I recall correctly.
He stated that
Again, having to do with the framing subcontractors, Holder Miller's operation of the crane, negligent operation of the crane, striking Bell, knocking him off the wall.
There was conflicting testimony on what happened. Bell himself testified that there was another worker there, and his name escapes me right now, but there was another gentleman
who may have swung the truss and knocked him off.
Basically turned it, and instead of it coming in front of Bell, it hit him in the back and knocked him down. That has nothing to do with whether or not there was a crane there and how the crane was operated. It had to do with what somebody else did. And Mr. Carney, the attorney that represented U.S. Home and Lennar, specifically said that. He said, he gave the example of, this is like a jogger running into a parked car and saying the car's an inherently dangerous instrumentality and that caused my accident, whereas it was a jogger running into a stopped
Did the record
vehicle.
ever establish who that third person, the other person on the wall was, as far as whether it was an employee of Holder Miller or of U.S. Homes?
The employment of Bell and the other individual are unclear.
Well, the allegations of the complaint are that Bell was employed by Holder Miller.
Correct, but if you get into the actual facts and the testimony, Bell testified that he was Frank Miller's, or Frank Sunderman, whatever name he's going by these days, that's who hired him, and that's who he thought he worked for. Later, somebody told him he worked for Holder Miller. He wasn't sure, and Mr. Carney testified at his deposition, to this day, I don't know who employed Bell. And it was unclear who employed this other individual. I believe his name may have been Krupple. No one was clear on this. I've been told this is somewhat common in some of the construction situations where people come on the job and sort of start working, and maybe there's a little confusion as to who works for who. Holder Miller filed a workers' comp claim against Lennar and U.S. Home. So there's a lot of confusion. There was confusion about who was paying employees every Friday. Bell testified he saw people in Lennar or U.S. Home hard hats out handing out paychecks, paying people, and he was saying paying the crew that he was working with. So this was never decided. We don't know who the person was that moved the trust, and because there was never any apportionment. So when you have that situation, it was U.S. Home's obligation to apportion that amount, and they haven't done that. In that situation, you can't hold Mid-Continent responsible for the whole package. There's never been a determination. Additionally, there's a factual issue on the employment status that we talked about, and that ties in directly with the workers' compensation exclusion. Even if this qualifies as an insured contract and there's a duty to defend, there's an exclusion for workers' compensation. That's different from the employer's liability exclusion. It's right before it in the policy, and that exclusion precludes coverage for acts, employees, things like that. We don't know whose employee was. That was a fact issue. It was never resolved. So we have the same situation. Unless the court has any other questions, I'd like to reserve my time for rebuttal.
Very good. Exactly 22 minutes gone. So you've got your 8. Thank you.
May it please the court, I'm Amy Stoll. I represent U.S. Home Corporation and Lennar Corporation. I also have Lennar Corporation's Deputy General Counsel here with me at the table. You got it exactly right, Judge Silverman, when you said that in Florida, the duty to defend is broad. It has always been broad. That has always been the law of Florida. You even quoted some of the cases I've got here, the Supreme Court of Florida, Jones versus Florida Guarantee Insurance. It is well settled that an insurer's duty to defend its insured against legal action arises when the complaint alleges facts that fairly and potentially bring the suit within policy coverage. Any doubts regarding the duty to defend must be resolved in favor of the insured.
Are there any cases that reiterate that language when they review a complaint that appears to also plead joint liability as well as direct negligence?
I don't know that there's this exact situation that we have in this case, but the Grissom case is a good example where you have allegations that are mixed. In other words, in Grissom versus Commercial Union, the causes of action alleged were breach of contract and injunctive relief. And the insurance company was arguing that it's not covered because there were allegations of intentional conduct. And the court, and this is a quote from the court, says the language of the complaint, at least marginally and by reasonable implication, could be construed to mean that Grissom intentionally filled in the water course, blah, 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 but negligently failed to provide adequate alternative drainage and thereby created conditions that resulted in unintentional damage. So the idea is, I think we all know that if a complaint mixes allegations of intentional conduct with allegations of negligent conduct, that's going to be covered. There's covered and non-covered claims being made, and those allegations may be in 1 count, they may be in 2 counts, they may be in 3 counts.
Well, the Supreme Court has said there has to be a separate cause of action. So how do you square that with some of the cases that seem to have mixed causes of action?
Well, I would agree that in that, I think it's the Goldschmidt case, that the court talks about the procedural rule, and they point to Florida Rule 1.1, whatever. Anyway, if you really drill down on the case, it's just as you said, they said there were no ultimate facts alleged. So the real holding in that, the part about there needing to be a separate cause of action because of the procedural rule is really just dicta, because what they decided on was that there were no ultimate facts in that complaint. But even if we assume that Florida procedural law requires you to have a separate count, that should not defeat Mid-Continent's duty to defend. The allegations, yes, they were mixed. There were allegations of direct liability. There were allegations of joint liability. There were allegations of vicarious liability.
What specifically in the amended complaint would you hang your hat on that you feel sounds in vicarious liability of U.S. Homes that would bring the coverage into play? Or the duty to defend?
There's several things. The complaint alleges that Holder Miller was a subcontractor or hired by U.S. Home. It alleges that Glenn Bell was an employee of Holder Miller. It also alleges in several places that all acts described in the complaint were performed by defendants themselves and defendants being U.S. Home and Holder Miller, and or their agents, representatives, employers. The acts herein were performed either with the full knowledge and consent of defendants, again that's U.S. Home and Holder Miller, and or were performed by agents. And then we get to the actual description of the accident, which is, this is the meat of the coconut, so to speak. Glenn Bell was directed by U.S. Home and or Holder Miller to stand on a wall to assist in placing of a truss. So you've got these giant trusses being placed on a roof.
You're at paragraph 15?
With a crane. Yes, that's at the record. It's 463 through 464. And then they say, this is how they describe it. While the truss was being placed into position, U.S. Home and Holder Miller negligently supervised their agents, representatives, and employees so as to cause the improper operation of a crane carrying a truss to strike plaintiff, causing him to fall off the wall several feet and resulting in severe and numerous personal injuries. The improper operation of a crane. Under Atlantic Coast Development Corporation versus Napoleon Steel, it's, as a matter of law, a crane in operation is an inherently dangerous activity. You know, there's much ado about, was this premises liability, and is that not non-delegable? You know, and Mid-Continent cites the Arminger case. I would just like to address that because the Arminger case is a case brought under the Foreign Substances Statute. And that was a case decided by this court. And the court looked at the statute and said, the statute says this is a non-delegable duty. And so therefore, this is not vicarious liability. Talking about that statute, the court also noted that in an indemnity case, in a footnote, they said in an indemnity case, the negligence of the contractor would be an issue. It's not an issue in the pleading the premises liability. But my point is that it's not applicable here, okay? This alleged an inherently dangerous activity, which is different than premises liability. Were there premises liability allegations mixed in the complaint? Yes.
Would there be vicarious liability if the crane, the operation of the crane was the responsibility of U.S. Homes?
Well, you're asking how, I mean, the record was clear that it was not, that the crane was hired by Holder Miller.
Where in the complaint does it say that?
In the complaint?
Yeah.
Well, the complaint says and or. So they're pleading in the alternative. In the complaint, they're saying U.S. Home and or Holder Miller directed him to stand on the crane and there was the improper
Which
operation.
sounds like...
That's not vicarious.
Right.
That's a claim for their active negligence in failing to properly supervise their employee.
Well, that can also be a vicarious liability claim, the failure to supervise. Okay, that's another basis besides the inherently liability claim. Another basis to hold them vicarious liable is in the allegations about the supervision. And for instance, the city of Miami Beach versus Perez, that's cited in our answer brief at page 15, holds that generally a builder or developer is not liable for its sub's negligence. There's an exception if the general contractor or builder retains control of the work to such an extent that the general contractor becomes liable for the negligence of the subcontractor. There's a lot of allegations in this complaint that could be deemed those type of allegations. U.S. Home oversaw, coordinated, obtained all necessary permitting, and completely supervised all daily activities. U.S. Home controlled all access to the work upon the homes being built. U.S. Home was actively participating in the construction of the job site to the extent that it directly influenced the manner in which the work was performed. Those are allegations that under City of Miami versus Perez, they could be vicariously liable for the supervision and control of Holder Miller. So that's a whole separate basis for vicarious liability that's pled in this complaint. And I want to bring the court's attention to the case Metropolitan Dade County versus CBM Industries of Minnesota, Inc. That's cited in our answer brief at page 16. This was a slip and fall case, and this is the third DCA case. It's very similar to here. The only difference is this was a slip and fall case, and it was not an inherently dangerous activity case. But what happened in that case is the county was sued for negligence because somebody slipped and fell on their property. The county had contracted with a subcontractor, CBM, for janitorial services. The county sought to invoke the indemnity provision with CBM, but the county was not entitled to indemnity for its own negligence. And so the CBM argued that they were sued for their own negligence, not vicarious liability, therefore we have no indemnity. And what the court said, they went through, the broad duties, and in this case, the county was sued in count 1 for negligence. There was only 2 counts in the complaint. Count 1 for negligence. Count 2 was against the subcontractor, CBM, for negligence. Very similar to what we have here. Just general negligence, 2 counts. And what the court said was, there was so in the first count, there was they alleged that the county, by and through its agents and employees, negligently and carelessly maintained and controlled the premises. That was in the first count against the county. In the second count against the subcontractor, CBM, they said that CBM was under a contract with the county to maintain the hallway where the incident in question occurred. And then the court concluded, and I quote, read in its entirety, the complaint states a cause of action for vicarious liability and negligence against the county, and they found a duty to defend. That's pretty much exactly what we've got going on here in this complaint. There are mixed allegations. Certainly, under the broad duty to defend, the allegations were sufficient to put Mid-Continent on notice that there could be an inherently dangerous activity doctrine argument made, and that is confirmed by when you get into the indemnity portion of the case by Michael Carney's testimony.
Before you go to that, I have one question about a finding made by the trial court. In paragraph 8 of its order, the court quotes from the amended complaint that Mr. Bell's injuries were, and here's the quote, directly attributable to Jeffrey Miller, Inc.'s performance of ongoing operations for U.S. Home Corporation. And you, I think, repeated that quote in your brief. So where in the complaint is that language?
That language is not in the complaint. I would readily admit that's not in the complaint. I believe what the court, maybe it shouldn't have been in quotes. I think what the court was saying there, what the trial judge was saying, that looking at this complaint, there are allegations that U.S. Home's liability would be directly attributable to Holder Miller.
So
I think that's.
You agree there is no specific allegation that the injuries were directly attributable to Holder Miller?
No, and you wouldn't expect to find that in the complaint. How would a plaintiff?
You would if it was pleaded as pure vicarious liability.
Well, I don't know if they would use the words directly attributable. Directly attributable, the plain language of that could mean a lot of things. It could mean vicarious liability. It could be, it really just by the plain meaning means caused by or resulting from.
Directly attributable for the performance of ongoing operations for U.S. Homes. That sounds a whole lot more like vicarious liability than some of what's in the complaint, which sounds like either joint or direct liability.
Again, we would admit that there are allegations that are mixed, okay? There are allegations of direct liability, but there are also allegations that under the broad duty would fairly and potentially raise the vicarious liability a claim.
So when the Supreme Court says vicarious liability must be specifically pleaded, it's a separate cause of action, what does that mean? How do you square that with mixed allegations?
I would say that this was a sloppily led complaint. And if you were to say that the insurance company, because of a pleading deficiency, this is what this is a pleading deficiency. Okay, let's assume you need this separate count under the procedural rule 1.110. Okay, so this complaint has a procedural deficiency. That's a defense. Mid-Continent could have showed up, defended the claim, and raised that as a defense. That's not what the law of Florida is on the duty to defend.
They could have if the defense was tendered during the pleading stage, was it?
The defense was tendered November 8th, 2008.
It was like 2 years after the pleading stage.
There was a late tender. However, Mid-Continent never raised the late tender as a coverage defense.
But you're saying they could have gotten this fixed had they come in and defended, but there was a late tender after the pleadings were completed, so isn't that shifting the burden to them that your client could have fixed by moving for more definite statement or moving to dismiss for failure to state a proper cause of action?
Well, if you look at the testimony of Michael Carney, our client did in fact raise that. There was a motion for partial summary judgment where he argued, you know, there's no premises liability here because there was no defective condition on the property, and that should be foreclosed by summary judgment. There was no evidence of direct liability by U.S. Home, and he testified that the plaintiff's lawyer, Bell, effectively argued to the trial court below, Judge Lovins, that the crane was an inherently dangerous activity on the property, and that therefore U.S. Home would be liable for that. And the trial judge, ruled on the motion for partial summary judgment that U.S. Home was going to be liable for everything that occurred within the zone of danger that was created by the crane. So U.S. Home did argue that, and that was much further along. That was in the summary judgment stage. And Mid-Continent, again, had they honored their duty to defend, probably would have been there. And again, as to the late notice, the trial court did address that, and there is case law in Florida, and there's also the claim statute that says that if they want to use late notice as a defense, as a coverage defense, that they need to put that in their reservation of rights within 30 days. They did not do that. The fact of the matter is, Mid-Continent wasn't going to cover this. They weren't going to cover it whether we had tendered it on day one or a year late. Their position was that because there's no separate count, that there were no allegations of vicarious liability, that they were not going to cover this. So it really would not have mattered. And again, Mid-Continent itself did not even bring up the late notice as a coverage defense. So, and this is what happens when you breach your duty to defend, and bad things happen in the case, which is what happened here, which is what Michael Carney testified to, is that the judge said they argued the inherently dangerous activity doctrine, rightly or wrongly, based on the pleadings. They argued it in that trial judge below, and Judge Levin said, you, U.S. Home, are going to be responsible for everything within the zone of danger created by the crane, and because of that, Michael Carney, being a good trial lawyer, recommended to his client that they settle this case. And they did that. And they did that because of that ruling, because they didn't see any liability. There was no evidence of direct liability against U.S. Home. But once the judge tells them that, Michael Carney, again, being a good lawyer, says, you know, we should settle this case because he's going to put up $8 to $10 million, and we need to settle it now. And I just want to address quickly the idea that Mid-Continent has proposed that we need to essentially retry all of the fault issues in this case in order to get our indemnity. That's not the law. Mid-Continent breached its duty to defend, and therefore the U.S. Home's liability is established by the settlement agreement, and that is the law of Florida, and it makes sense. It makes sense because what would be the reason to settle something if you can never get indemnity unless you have to try all those fault issues? Why would an insured ever settle? I mean, under that scenario, the best thing that U.S. Home could have done is gone ahead, tried the fault issues, and guess what? If there was an $8 million excess judgment entered against them, then we'd be here on a bad faith case instead of just on the limits of the policy. It would discourage any insurers from actually ever settling a case. If they have to, you settle the case because you don't want to try it, because you have exposure. And that should not be confused with the allocation issue. The allocation issue is, you paid a pot of money. What did you pay that money for? There were covered claims and there were non-covered claims. Why was the reason you paid that money? And we met our burden. That was our burden, and we met it. And we met it with the testimony of Michael Carney, who explained that once that summary judgment happened, and once that judge said, you're going to be tagged for everything that's in the zone of danger by the crane, that's why we settled the case. That's why they settled it at the time that they did and for the amount that they did. And in his mind, there was no evidence of direct liability against U.S. Home, and so the entire allocation was for that vicarious claim. That's why they settled the case. And so we met our burden. Mid-Continent they could have taken the deposition of the plaintiff's attorney. I don't know, they could have had an expert. They could have done a lot of different things. They didn't do any of that.
Did Mid-Continent argue to the trial court on the indemnification aspect that there needed to be a trial to flesh that out as opposed to summary judgment?
Did they argue? I'm sorry.
Did they argue that there needed to be a trial on the indemnification question? How was the settlement reached? Was it reached on direct negligence versus vicarious liability? I just don't recall if they'd asked for a trial or if they agreed, no, it's right for summary judgment, just we should win.
Well, they did argue that there should be a trial on that in response to our motion for summary judgment. But they also filed their own cross motion for summary judgment that said there were no disputed issues of fact. So, yes, they did argue that. But again, there was no contradictory evidence on this point. The U.S. Home, the general counsel for U.S. Home that was deposed explained that the reason that they settled the case was because their trial counsel had advised about this ruling and that U.S. Home was going to be responsible for the crane and for anything that's happening on that day with that crane, even though U.S. Home was not there and had no forces on the job. And they made the decision to settle the case. And Michael Carney testified the same way. There was no conflicting or contradictory testimony. There's a lot of talk in Mid-Continent's briefs about conflicting or contradictory testimony, but there really isn't any. They didn't really point to any. And just real quickly on the employer exclusion, because that we talked about that a little bit, there's no genuine issue of fact there either. Does it matter? It doesn't matter whether Bell was an employee of Sunderman, Holdemiller subcontractor, or Holdemiller. It is undisputed that Bell was not an employee of U.S. Home. The U.S. Home representative testified clearly, no, he was never a direct employee, he was never paid by anyone, let alone U.S. Home. Bell himself testified that he was hired by a gentleman named Frank Sunderman, and that he never spoke at all to a U.S. Home or Lennar representative. So there's no question that Bell was not a direct employee. And the court found that also he was not, so even if he was Sunderman or Holdemiller, let's just assume he's a Sunderman employee or a Holdemiller employee. Let's assume that's a true fact. Even if it is, still not U.S. Home's employee. U.S. Home was not a statutory employer, and the court found that as a matter of law. Because U.S. Home was the builder and the owner of these properties, and U.S. Home was building out this entire subdivision to sell, and they weren't contracting. It's different than when an owner owns a lot, and then they hire a contractor to build their house. That's not what happened here. U.S. Home owned this entire subdivision. They were building single-family homes. They were selling them like hotcakes because the market was good then. And they were going to build out that entire subdivision regardless of whether they had a purchase and sale contract. And they maintained ownership of the property until it was built and it closed. And so based on those facts that were undisputed, the judge found that under Kiro versus Ryland Home Corp. And under the Cadillac Fairview case, that U.S. Home was not a statutory employer as a matter of law. Therefore, the workers' compensation exclusion does not apply. think unless you guys have any questions for me.
Thank you.
Hopefully I won't take up too much more time. There were a couple things I would like to address. U.S. Home represented that it's already been determined that that full settlement amount was for vicarious liability for Holder Miller's actions. That's simply not true. There's nothing in this record that says that. Their own attorney, Mr. Carney, who was deposed by Mid-Continent's counsel, he was their attorney in the case. He said, we were going to jury and there was going to be a verdict form that had vicarious and direct liability on it. It was not decided. You can't just lump that onto Mid-Continent. It was never decided, and it has to be before you can pass that along. Once an insured settles, if there's been a breach of a duty to defend, the insured still has to show coverage. The only way they get there is to apportion it, because they've acknowledged in their own briefs that liability only comes into play if they're being held responsible solely for Holder Miller's actions. There was also a discussion about what Mr. Carney testified as to what another attorney said and what the judge said. That's all hearsay. That's not evidence. There's, again, no record evidence of these facts. There's just been no determination made of it. Mid-Continent did cross-move for summary judgment on the duty to indemnify, but on different issues, specifically on the comp exclusion, I believe was one of them. And in response to U.S. Home's summary judgment motion, we did argue below, as we have on appeal, that there were factual issues, unresolved factual issues, including as to the apportionment of the settlement funds. And keep in mind, we have both Lennar and U.S. Home were settled. Only U.S. Home can qualify under the insured contract provision. And there was no apportionment made even between U.S. Home and Lennar in that settlement. It was one lump payment paid by Lennar, no determination as to what money came from where. And also, the other thing that they argued was late notice and the claims administration statute. That's a separate issue. As on the duty to defend, we raised the argument that you only get your defense costs from tender forward. The only way an insurance company knows you've been sued is if it gets tendered. They don't just go out and check court dockets regularly to see if somebody might be claiming to be an additional insured under a policy where they're not actually named somewhere. That's the purpose of the notice provision. And in the Beeville case that they relied on saying they get pre-tender suits, there was evidence in that record that the carrier knew of the suit within a month of it being filed. The carrier took the position that a year later, when an attorney actually forwarded the suit papers, that was the date. But there's nothing that stands for the proposition that you get pre-tender fees and costs. If you don't bother to let the insurance company know, they shouldn't be held responsible for that. And unless there's anything else the court has for me, we would ask that the court reverse on both the duty to defend and the duty to indemnify. Thank you.
Thank you, counsel. Well argued with some complicated issues. So thank you. The next case is Bokros versus Free Sun